Hi, welcome to this episode of Understanding Tort Law, the Law of Private Nuisance. This is our second part of our discussion of remedies. And the first case that we're going to look at is Sturgis and Bridgman. Okay, so in this case, the defendant is a confectioner, and one of the things that he does is he has a mechanical mortar and pestle set up in his premises, and he uses this to grind up produce, meat, it seems, to make sweets or lollies or whatever you call them in your part of the world. Okay, now in the beginning, this isn't problematic because the mortar and pestle is situated near a wall in the defendant's property that is adjacent to a courtyard in the plaintiff's property, and the courtyard's open. Vibration travels through the wall, but it doesn't matter because it's just going into an empty area. I have this sort of slide here that may help you to see the point. So the M is where the mortar and pestle is, and the vibrations are just going through into this courtyard, and it's not bothering anybody. But sometime later on, the plaintiff, who is a doctor, decides to as it were, fill in the courtyard and use that space as a consulting room. So we have this situation. And now there is a problem because the vibrations pass through the wall into the plaintiff's consulting room, causing noise and so on. And he can't use it as a consulting room because it's too noisy and so on in there. Okay, now the plaintiff, of course, is entitled to move his consulting room. It's his house. He's not committing any wrong against the defendant by doing that. And on the face of it, this is a nuisance. It's the kind of thing that we've seen in other cases can be a nuisance. But the defendant says there's something special about this case that means it shouldn't constitute a nuisance. And the special thing is this. They say, we've been operating this mortar and pestle without problem for more than 20 years. It hasn't been a problem. We've been doing this for more than 20 years, and it hasn't been a problem. And then the plaintiff moves his consulting room, and then it becomes a problem. You need to take that into account when determining whether it's a nuisance and what should happen in response. Now, the court says there is a way in which you could make an argument of this kind work, but it's a very particular way. You can't just say, hey, I've been doing this for a long time, therefore I should succeed. Right? But there is a way that you might be able to run an argument of this kind that would work, and that is you might be able to show that your activity has generated an easement, and you can rely on this easement to defend yourself against the plaintiff's claim. Now, in order to understand this, of course, we need to spend a little bit of time talking about what easements are. Now, easements are part of the law of property, and like most things in the law of property, they're complicated and difficult. And so we're not going to go into a huge amount of detail here. We're just going to discuss easements to the extent that we need to in order to understand what's going on in this case, and also to a certain extent in the next case. Okay, an easement. What is an easement? An easement is a right to the use of somebody else's land. A right to the use of somebody else's land. Now, on the face of it, it might seem really strange that there would be such a thing, a right to the use of someone else's land. But actually, if you think about it, there are pretty common examples. The most common example that you would have no doubt experienced is a right-of-way. So let's just take an example. I have a property and I subdivide it. The rear of my property, the part away from the street, I subdivide, I create a new property there, and I sell that property. The problem is that to get to that property, people have to cross my land. Right? There's a driveway I've got, but if the driveway is on my land, they have to cross my land. Well, what can I do about that? What can they do? Well, I can give them a right of way, a right of way. They have a right, an entitlement, right? A right to way across my land, right? A right of way across my land. And that's one form of an easement. Okay, now it's an important thing about easements that they run with the land. That is, they're part of the law of property. They're not part of the law of contract, even if they're created through contracts, usually. They are part of the law of property. And that means when the people who now own the section at the back of mine, when they sell it, the new person, the new owner, will have a right to cross the right-of-way. Okay, and the jargon for that is to say that easements run with the land. Okay, the easement belongs to the property, as it were. Okay, now, easements are normally created through consent, in fact through contract. They're part of the law of property, but they're created through contract. Then the point there, the key thing is to see easements are normally created intentionally. Like in this imaginary example, I've subdivided the property. I want to give people access to the rear section, so I intentionally create a right-of-way over the property. But they can be created in other ways also. They can be created by what's known as prescription. And this is if a certain activity occurs for a certain period of time, then an easement will come into effect, even if the parties didn't specifically intend that to happen. That's known as prescription. And there are various prescription periods laid down in the law, 5, 10, 20 years. We don't need to know all about this. The key thing is the current the prescription period relevant for this period is 20 years. So if the defendant had been doing the appropriate activity, we'll discuss what that is in a minute. If the defendant had been doing the appropriate activity for 20 years, the defendant could have gained an easement through prescription. And that's, on the face of it, what the defendant is arguing here. We were doing this for 20 years. So maybe we've gained a right through prescription to keep doing this. We've met the period, right? We've met the period. The period is 20 years. We've been doing this for 20 years. So maybe we've got an easement by prescription. Now, let me give you an example of how this might work. Now, I should say this is how it would work at common law. There are jurisdictions in which it can't work like this anymore because of the influence of statute on land law. But at common law, this is how it might work. This is an example of how a prescription might work. Let's just say that you and I are neighbours, and in order to get to the bus, I cut through your property. In the morning, I get up and I walk through your property. And when I get home, I get off the bus and walk through your property to get home. And imagine that you've seen me doing this. I've been doing this for years, and you've never said anything about it. You've never said, hey, Alan, that's fine, no worries, you can cross my property. But you've never said, hey, stop crossing my property. You never said anything. Right? The idea is if you don't say anything for the relevant period of time, let's just say 20 years, I gain an easement through prescription. So if I've been doing this for 20 years, crossing your property, and you haven't said anything, right? And then after 20 years, you say, hey, stop crossing my property. I can say, no, I've gained an easement through prescription to cross your property. You're not entitled to stop me. And it's not only are you not entitled to stop me, if, for example, you put up a fence so that I can't cross, I could sue you for nuisance, for interfering. Even though the fence is entirely on your property, I could sue you for nuisance because you are interfering with my easement. Similarly, in the case where there's a driveway, right of way, if I block the right of way, even though it's on my property, the owners of the property behind me could sue me to make me remove the obstruction. Okay, so this is a curious and interesting aspect of the law. But the issue here is, can the defendants make use of it? In this context, can they say, because we've been doing this for 20 years, we've gained an easement, and so we can continue to use our mortar and pestle even though it's causing this noise? And the court says no. And the reason that the court says no is that in order for there to be an easement through prescription, there has to have been acquiescence by the plaintiff, in this case, for the relevant period. That is, there has to have been, the defendant has to have been doing something that would have constituted a legal wrong, and the plaintiff must have acquiesced in that activity for the prescription period, here 20 years. So if the defendant had been committing a nuisance for 20 years and the plaintiff had acquiesced in that for 20 years, then it may have been possible for the defendant now to say, well, we've acquired an easement, we can keep doing it. The problem for the defendant, however, is that though they have been operating a mortar and pestle for 20 years, they have not been committing a nuisance for 20 years. It only becomes a nuisance at the point at which the plaintiff moves his consulting room. The thing is, you see, before the plaintiff moved the consulting room, the plaintiff had nothing about which to complain. The plaintiff could not have, until that point, the plaintiff could not have legitimately complained about the vibrations caused by the mortar and pestle. So until the plaintiff moved the consulting room, there can have been no acquiescence by the plaintiff. The plaintiff was not acquiescing in anything. There was no legal wrong there at all. It's only when the consulting room is moved that the nuisance is created, and that's the moment at which we can start counting for the prescription period. The problem was the plaintiff then complained. Okay, so in order for there to be an easement, there has to be a legal wrong that the plaintiff is acquiescing in, or the party, whoever it is acquiescing in for the prescription period. But in this case, there has been no acquiescence. There was no nuisance originally. When the plaintiff moved his consulting room, that's when the nuisance began, and that's when the plaintiff complained. So there can be no easement. But given that there can be no easement, there is a nuisance. Given that there is a nuisance, the court said, and given that there will be a nuisance continuing into the future, the plaintiff is entitled to an injunction to stop that nuisance from occurring. That's Sturgis and Bridgman. Okay, so our next case is an infamous decision of the English Court of Appeal in Miller and Jackson. In this case, the plaintiff purchases some property, a house, next to the defendant's cricket ground. And sometimes balls are hit out of the cricket ground into the plaintiff's property, and this has caused damage to the plaintiff's property. It's caused roof tiles to be broken, smashed windows, and so on. And it causes, and it hasn't injured, no one has been injured yet, but there's an obvious risk of someone being hit by the cricket ball and injured. As Lord Justice Cumming Bruce describes it, someone might be injured by thunderbolts from the heavens. Okay, now the defendants in this case have done their best to ensure that this doesn't happen. They have thought about moving the pitch, that is, for those who don't play cricket, thought about moving the sort of direction of where the bowler bowls from and the batsman hits to try and make it less likely that the balls would go over into the plaintiff's property. They have put up fences, but none of these things have worked. Some of the fences have fallen over because they were too high in the wind, and so on and so on. Anyway, none of this has worked. So on the face of it, it looks like this is a nuisance. There's physical damage to the plaintiff's property, and it's ongoing. It will continue into the future unless the court awards an injunction. What's more, the plaintiffs are suffering from a fair amount of anxiety as the result of this. So it's not just the physical damage that they're worried about. They're worried that someone's going to get hurt. They're worried about the fact that people from the cricket club keep, when the balls get hit over, keep coming and asking for their balls back. They feel their privacy has been violated, and so on. As a result of this, they leave their house during Wednesdays, Fridays, and on the weekends. That's when cricket has been practiced or played. They leave their house because they're so upset about being there during these periods. Now, one of the things that the defendant says in response to these allegations is that they have been there for 70 years before the houses were built. It used to be a cricket ground surrounded by farmland, and they'd been playing cricket there. The club had been there for 70 years, and it was never a problem. As Lord Dennings says, the animals did not mind the cricket. Okay, so they'd been there for 70 years, it wasn't a problem, and then along come some developers and build these houses The plaintiffs move in to the houses and then they complain. And the defendant is saying this is totally unfair. We've been here for 70 years, no problems. Then all of a sudden these people move in and it becomes a nuisance. Surely we can't be required to close down the cricket club. We've done everything we can to ensure that our cricket playing is safe, that it doesn't cause any problems. It hasn't worked. Surely we're not going to be closed down. Now, the court of first instance, that is the trial court that heard this case, did award an injunction. And this is an appeal from that decision. Now, as you can see in this, I hope, not entirely unhelpful table here, there are 3 different positions taken by the judges on the Court of Appeal. According to Lord Denning, he would have said that there is no nuisance. And so he wouldn't have awarded damages. And obviously, if there's no nuisance, there'd be no injunction. Now, because he realises that the majority of the court is going the other way, he sort of goes along with them and says, okay, I'll agree to an award of damages, but no injunction. Lord Justice Geoffrey Lane says that there is a nuisance, there should be damages, and there should also be an injunction. And Lord Justice Cumming Bruce says that there is a nuisance, there should be damages, but he wouldn't award an injunction. Okay, so the result is that there is a nuisance, there will be damages, but no injunction. Okay, let's take these judgments in turn, not in the order that they are in the case, but in the order that I think is most useful for us. So let's start with Lord Justice Geoffrey Lane. Geoffrey Lane's position might not surprise you given what we've studied so far. Looks like there's serious damage being caused to the plaintiff's property. There's roof tiles being smashed, windows being broken. There's a danger to physical damage to the plaintiff's person. That's serious enough for there to be a nuisance. And although Geoffrey Lane is rather reluctant, he says, well, in these circumstances, unfortunately, we have to award an injunction. It's regrettable given the circumstances, but there's no question that an injunction is warranted. And this is really just following the decision then in Sturgis and Bridgman. That's Lord Justice Geoffrey Lane. Lord Denning produces a rather different view. This is how he begins his judgment. He says, in summertime, village cricket is the delight of everyone. Nearly every village has its own cricket field where the young men play and the old men watch. In the village of Lince in County Durham, they have their own ground where they have played these last 70 years. They tend it well. The wicket area is well rolled and mown. The outfield is kept short. There is a good clubhouse for the players and seats for the onlookers. The village team play there on Saturdays and Sundays. They belong to a league competing with the neighbouring villages. On other evenings after work they practice while the light lasts. Yet now, after these 70 years, a judge of the High Court has ordered that they must not play there anymore. He has issued an injunction to stop them. He has done it at the insistence of a newcomer who is no lover of cricket. This newcomer has built, or has built for him, a house on the edge of the cricket ground, which 4 years ago was a field where cattle grazed. The animals did not mind the cricket. But now this adjoining field has been turned into a housing estate. The newcomer bought one of the houses on the edge of the cricket ground. No doubt the open space was a selling point. Now he complains that, when a batsman hits a six, the ball has been known to land in his garden, on or near his house. His wife has got so upset about it that they always go out at weekends. They do not go into the garden when cricket is being played. They say that this is intolerable. So they ask the judge to stop the cricket being played, and the judge, much against his will, has felt that he must order the cricket to be stopped, with the consequences, I suppose, that the Lince Cricket Club will disappear. The cricket ground will be turned to some other use, I expect for more houses or a factory. The young men will turn to other things instead of cricket. The whole village will be much the poorer, and all this because of a newcomer who has just bought a house next to the cricket ground. Now, I don't know what you make of that opening passage to Lord Denning's judgment. I'll leave it for you to decide whether you think judges really ought to behave in this way. But at least notice this. Even having just read Lord Denning's introduction, that is his just statement of what the facts are, we already know who's going to win the case, right? We already know whose side Denning's on. It's pretty clear. By the end of the first sentence, in fact, you know who's going to win. Okay, pretty clearly, Lord Dennings' sympathies are with the defendant in this case. He goes on to say, "No one has been hurt at all by any of these balls, either before or after the high fence was erected. There has, however, been some damage to property, even since the high fence was erected. The Cricket Club have offered to remedy all the damage and pay all the expenses. They have offered to supply and fit unbreakable glass in the windows and shutters or safeguards for them. They have offered to supply and fit a safety net over the garden whenever cricket has been played. In short, they have done everything possible short of stopping playing cricket on the ground at all, but Mrs. Miller and her husband have remained unmoved. Every offer by the club has been rejected. They demand the closing down of the cricket club. Nothing else will satisfy them. They have obtained legal aid to sue the cricket club." Now, this is all to say that the defendants are doing their best. They're being completely reasonable. They're trying as hard as they can to avoid this, to avoid the problems, and the plaintiffs are being totally unreasonable in Lord Dennings' view. The defendants are being reasonable, the plaintiffs are being unreasonable. And he seems to think, although I can't quite see why anybody would think this is relevant, that it matters that the plaintiffs obtained legal aid. He thinks that's just the end of the matter. That it's just outrageous that someone would obtain legal aid to sue in this context. How unreasonable could you possibly be? Okay, so on the one hand, the plaintiffs are being unreasonable. On the other hand, the defendant is doing his best. Going on. In support of the case, the plaintiff relies on the dictum of Lord Reid in Bolton and Stone. If cricket cannot be played on a ground without creating a substantial risk, then it should not be played there at all. I would agree with that saying if the houses or road were there first and the cricket ground came there second. We would not allow the garden of Lincoln's Inn to be turned into a cricket ground. It would be too dangerous for windows and people. But I do not agree with Lord Reid's dictum when the cricket ground has been there for 70 years and that houses are newly built at the very edge of it. I recognise that the cricket club are under a duty to use all reasonable care consistently with the playing of the game of cricket, but I do not think the cricket club can be expected to give up the game of cricket altogether. After all, they have their rights in the cricket ground. They have spent money, labour and love in the making of it, and they have the right to play on it as they have done for 70 years. Is this all to be rendered useless to them by the thoughtless and selfish act of an estate developer in building right up to the edge of it? Can the developer or purchaser of a house say to the cricket club, "Stop playing, clear out"? I do not think so. Now, there's three things that we need to notice here. The first is the rather astonishing, in effect, overruling of the House of Lords by a judge sitting on the Court of Appeal here. The decision in Bolton and Stone is a decision by the House of Lords, in which Lord Reid says this passage that is quoted here by Lord Denning. And what's Lord Denning's response? He says, I just don't agree with it as it applies in this case. The fact that the decision is coming from the House of Lords doesn't matter at all to Lord Denning. That's just the way Lord Denning was. But that's the first thing we need to consider. The second thing we need to consider is that on the face of it, what Lord Denning is talking about here is negligence. He's talking about what can be expected of people, who's at fault for whatever happened, and his position basically is that the defendant is not at fault for this, and while the plaintiff may or may not be at fault for this, at least the company that sold the houses to the plaintiff, the development company, was at fault. So because the defendant's not at fault, the defendant's not going to be liable. The other thing is, and here we see this old chestnut again, who got there first according to Lord Denning matters. The defendant got there first, and that's a reason why, in his view, the defendant is going to win. Okay, going on. I would therefore adopt this test. Is the use by the cricket club of this ground for playing cricket a reasonable use of it? To my mind, it is a most reasonable use. Just consider the circumstances. For over 70 years, the game of cricket has been played on this ground to the great benefit of the community as a whole and injury to none. Okay, so again we see appeals to reasonableness, where reasonableness just seems to be what the judge considers to be appropriate. the question is it reasonable to run a cricket ground, to run a cricket club on a cricket ground and play cricket on it? And Lord Dennings' view is, yeah, I like cricket, so yeah, I think it's reasonable. So how do we answer the question, is it reasonable according to Lord Denning? What we do is look at the public interest. In this case, of course, it's the particular judge's beliefs about the public interest, but that's how we figure it out. What we do is we look at the public interest and we say, is the defendant's activity in the public interest? If the answer is yes, then we say that the defendant's activity is reasonable and therefore the plaintiff cannot get an injunction. Okay, so in summary, we can say that there's no injunction because, first of all, the defendants were doing their best. Secondly, because the defendant got there first. Thirdly, because the defendant's use of land was reasonable. That was meaning that it was in the public interest. And fourth, although we haven't looked at this in any detail, basically because the plaintiffs are neurotic. That's Dennings' view. Okay, so now it's a little bit hard, for reasons I enunciated earlier, to understand quite how to take Dennings' judgment, because he intends it to show not only that there will be no injunction, but that there would be no nuisance at all. But given that he knew the other two judges were going to go the other way on that issue, he was prepared to sort of fudge this. So it's not, in his view, there would be no nuisance at all, but what the decision actually stands for is that on this basis there will be no injunction. So it seems, the position adopted seems to be, if the public interest requires it, there'll be no injunction. If the defendant's activity is in the public interest, there'll be no injunction. Okay, so our next case is Kennaway and Thompson, another decision of the English Court of Appeal, but this time with Denning no longer in the picture. This case is very similar to Miller and Jackson. The plaintiffs here moved into a house that was built on the edge of a lake that was used frequently for motorboat racing. So the defendants were there first, racing their motorboats. The plaintiff moves into a house on the edge of the lake, and she complains about the noise emanating from the motorboats. It's really loud, and when the racing's on, she can't stand to be there, and goes and stays with her mother. Okay, now the trial judge in this case did exactly the opposite to the trial judge in Miller and Jackson. As a result of the decision of the Court of Appeal in Miller and Jackson, the trial judge said, yes, this is a nuisance, but because the motorboat racing is in the public interest, I won't issue an injunction. And it's against that decision that the plaintiff is appealing here. Now, the trial judge's decision here is overturned by a unanimous bench of the Court of Appeal. And what the Court of Appeal do here is reassert the Schaefer rule, right? They reassert the Schaefer rule, and they say, was the interest of the plaintiff's right small in this case? No, it was not small. It was a significant violation of the plaintiff's rights in her property. Was the injury capable of being estimated in money? Well, maybe not. Could it be compensated by a small money payment? No, it would need a significant money payment. Would it be oppressive to the defendant to award an injunction? Well, perhaps it would, but we already said that 1 in 3 are false, so therefore an injunction will be awarded. The plaintiff was awarded an injunction. So what the court did in this case is it simply flatly refused to follow Miller and Jackson. The court couldn't overrule Miller and Jackson because it was still the Court of Appeal, but it refused to follow Miller and Jackson. And after this, it seemed fair to say that Miller and Jackson was a dead letter. It seemed fair to say because it looks as if at least part of it has been or has attempted to be resurrected in the next case that we'll look at. Okay, so the case I'm talking about is Coventry and Lawrence, a decision of the Supreme Court of the United Kingdom. And I think a very worrying, unfortunate decision, or at least it contains within it aspects that are very unfortunate and worrying for reasons that I'll try and convince you of later. Anyway, we don't need to talk about the facts of this case because they're so similar to cases that we've already looked at. In fact, they're so similar to Kenaway and Thompson, with the exception that we're not dealing with boats here, we're dealing with cars and the like. But the first thing to say about this case is that it raises, again, the issue of an easement, like Sturgis and Bridgman did. And the way that this issue is dealt with by Lord Neuberger is very similar to the way in which Lord Justice Thesiger did in Sturgis and Bridgman. And that is, Lord Neuberger insists that in order to claim that you've gained an easement by prescription, you have to argue that you were committing a nuisance for 20 years. It's not enough to say that you were making noise for 20 years that now has become a nuisance. Okay, so the defendant tries to argue that there was an easement, but that gets knocked down for basically the same reason that it did in Sturgis and Bridgman. There can be no easement here because you haven't been committing a nuisance for a 20-year period, right? So the prescription period hasn't expired. Okay, so that's the issue of an easement. Now we must think about, is there a nuisance here? And if there is, what should be done about it? This is what Lord Neuberger has to say. He says, "In my view, the law is clear, at least in a case such as the present, where the claimant in nuisance uses her property for essentially the same purpose as that for which it has been used by her predecessors since before the alleged nuisance started. In such a case, the defence of coming to the nuisance must fail. For over 180 years, it has been assumed and authoritatively stated to be the law that it is no defence for a defendant to a nuisance claim to argue that the claimant came to the nuisance. There is much more room for argument that a claimant who builds on or changes the use of her property after the defendant has started the activity alleged to cause a nuisance by noise or any other emission offensive to the senses should not have the same rights to complain about that activity as she would have had if her building, work or change of use had occurred before the defendant's activity had started. That raises a rather different point from the issue of coming to the nuisance, namely whether an alteration in the claimant's property after the activity in question has started can give rise to a claim of nuisance if the activity would not have been a nuisance had the alteration not occurred." Okay, so what is Lord Neuberger saying here? He is saying that ordinarily who got there first does not matter. It's no defence to say I got there first, ordinarily. However, it might be a defence. That's all he says, might. It might be a defence when the plaintiff has changed the way in which she used the property. Now, Lord Neuberger claims that this situation, what happens when the plaintiff has changed the way in which she uses the property, right, is different. He says there is tons of case law establishing that ordinarily it doesn't matter who got there first. But it's an open question as to what we should do when the plaintiff has changed the use of the land. Now, I put it to you that that is completely untrue. It is not true that there is no case law on this matter. There is case law and we have studied it, and what's more, Lord Neuberger must have known about it. That case law is Sturgis and Bridgman and Kenaway and Thompson. Those were cases where the use of the land changed, right? And nevertheless, an injunction, a nuisance was found and an injunction awarded. In fact, you can argue that in a certain sense, any of the cases that we've looked at are cases of this kind. In short, what I'm saying is, and I don't really know how to put this, except to say it bluntly, either Lord Neuberger doesn't know about the case law, or he doesn't understand it, or there's a third possibility, but we won't go there. Anyway, that's Lord Neuberger. Now, he says a bit more about this. One thing we might ask is, what is Lord Neuberger's position with respect to the Schaefer rule? And his position in this regard is impossible to explain consistently. What he says is this. He says he's basically happy with the Schaefer rule. However, he wants it to be treated more as a guideline than as a hard and fast rule. Okay, so he would allow possibly there to be some exceptions to the Schaefer rule. Now, we might immediately ask, well, do you really believe in the Schaefer rule if you want to treat it not as a guideline rather than a rule? But in any case, there's something more important here, and that is that Lord Neuberger wants the public interest to be considered in this context. So, when thinking about whether an injunction will be awarded to prevent future nuisances, Lord Neuberger wants the public interest to be considered. Now, my question is, how is that consistent with the Schaefer rule? Right, how can you say, I believe in the Schaefer rule and I want the public interest to be considered, when the public interest was one of the things that was excluded by the Schaefer rule? What I think we see here, in fact, is that Lord Neuberger, I don't really know how to put this. I don't believe that Lord Neuberger understands what the Schaefer rule is. If the Schaefer rule holds, then the public interest is irrelevant. So you can't say, I support the Schaefer rule and I think we should consider the public interest. Doesn't make sense. Okay, now, that's Lord Neuberger. Now, whatever one thinks about Lord Neuberger, this really pales into insignificance when one compares Lord Neuberger's judgment with that offered by Lord Sumption. This is what Lord Sumption says. There is much to be said for the view that damages are ordinarily an adequate remedy for nuisance, and that an injunction should not usually be granted in a case where it is likely that conflicting interests are engaged other than the parties' interests. In particular, it may well be that an injunction should as a matter of principle not be granted in a case where a use of land to which objection is taken requires and has received planning permission. However, at this stage, in the absence of argument on these points, I can do no more than identify them as calling for consideration in the cases which they may arise. So, Lord Sumption is actually advancing the view that the intuitive position with which we began, that if there is an ongoing nuisance it should be stopped, he actually questions this and says maybe the default position should be no, that you would only get damages, that is, damages in lieu of an injunction, damages in advance, compensation in advance. Now, this is not, and I have to stress this because a lot of people seem to forget this view is not accepted by the other judges on the court. For example, Lord Mance says, with reference to Lord Sumption's concluding paragraph, I would not therefore presently be persuaded by a view that damages are ordinarily an adequate remedy for nuisance, and that an injunction should not usually be granted in a case where it is likely that conflicting interests are engaged other than the parties' interests. A suggested example of the latter being given as a case where a use of land has received planning permission. I would see this as putting the significance of planning permission and public benefit too high. In the context of the remedy to be afforded for a private nuisance, as already indicated, I agree with Lord Neuberger's nuanced approach. Okay, now, what is to be said about this? Well, I'll give my full response later, but the key thing I want to bring out now is to notice, on the face of it, we're heading for a period of chaos. At least those of you who live in England and Wales are. Because Lord Neuberger's nuanced approach is not a set of principles, it is a set of gestures. Right, there's the Schaefer rule that applies as a guideline, and then there's the public interest. This is not a system of principles, this is a system of gestures. And then on the other hand, we have Lord Sumption advancing this view that we should really rather radically change the way that we deal with the awarding of an injunction. It might take a long time for this issue to be sorted out. I want to talk about how it seems to me this issue ought to be sorted out, and I'll do that next.